Okay, we are indeed going to say good afternoon, Martina. Are all the participants on, ready to be on? They're all here?
Yes, Mr. Mayor, everyone is here.
Okay. Okay, we will officially get underway then, and welcome to a special meeting here of the Township of Douro-Dummer. We welcome everyone, and I'm going to take the roll before we indeed do get underway. Deputy Mayor Moher.
Here.
Councillor Watt. Tom, you were frozen there. Maybe there's a problem. No, we're not hearing you. Councillor Landsman. Okay, Sheila and Councillor Watson.
I'm here.
Okay, we do have a quorum here. Whoops. And we will officially call our meeting to order. We get underway here now. Our land acknowledgement, we respectfully acknowledge that we're on the treaty and traditional territory of the Mississauga and Anishinaabe, and we offer our gratitude to the First Nations peoples for their care for and their teachings about our earth and our relations. May we honor those teachings. Is there any pecuniary interest to anyone with the matters we're dealing with in this special meeting? Okay, see no hands. The agenda that's before us, a motion please to adopt that agenda.
I'll make a motion. And can you hear me now?
We can hear you now. Good. Tom
Perfect.
and Heather, all in favor? That motion is approved. Okay, for the next 1 hour, actually 58 minutes, we are here for one subject and one subject only, and that is to hear from Tony Fleming, our Integrity Commissioner. And this is a training session for Council. It's an opportunity for all of Council to be updated on the latest things we should do and shouldn't do. And we are delighted to have Tony. Tony, I'm not seeing your face yet. There he is here. Tony, very experienced gentleman in this line of work. He comes to us from beautiful downtown Kingston, and he has a slide deck for us, and he has a lot of great information. So without further ado, Tony, welcome to the Township of Douro-Dummer. You're on.
Your worship. Someday I may actually see you folks in person.
Someday.
That'd be just wonderful.
Someday soon, please.
It will. There was a song by that name, actually. Yeah.
I'm getting tired of my house, I can tell you that. So
You got it.
as you said, without further ado, I am working remotely today, and for reasons that are technological that I don't understand, I can't share my screen through my server at work. So staff have agreed to show the slides for me, and I'll just ask that we get them advanced as we go. So can everyone see the slides now?
Yes.
Yep, doing good.
Great. So if we could advance the slides, please. So I'm going to talk about 4 things. I appreciate we have just under an hour, so it's a bit of a optimistic or a aggressive agenda, but we'll see how far we can get. What I'm going to do, your worship, subject to your approval, is at the end of each session or section rather, I'll simply ask if there are any questions, and I'm not sure what your preference is in terms of whether those come through the chair or how you'd like to manage that.
You would prefer then, Tony, for questions after each segment as opposed to the very end?
Yeah, I think that makes more sense, your worship. I think people will have them a little more freshly in their mind, make for a bit better back and forth.
Okay, I will say then go through the chair and we can keep some semblance of order, and then we'll get the questions answered that way.
All right, I think that makes sense because I can't really see all of council anyway, so I'll ask you to move that through the chair.
That's great.
So we're going to talk about meetings of council. We'll talk then about conflicts of interest. Then I'm going to move into council staff relations, and then follow up with a high-level review of just a couple of key pieces from your new procedural bylaw, mostly dealing with motions. We can have the next slide. So we're talking about council meetings. Very standard stuff that we should all be familiar with. Every council has a procedural bylaw. I understand you just amended yours. Meetings have to be conducted in accordance with the procedural bylaw. No secret ballots unless you are an upper tier and you're appointing a warden, or if you are appointing a meeting chair. And of course, we can have recorded votes. The interesting piece for me is the next slide, which talks about what is a council meeting. And so a few years ago, the act was amended to make it a little clearer and incorporate some findings from cases that had been interpreting what a meeting was or wasn't through the years. So right now, there are two pieces that are important that have to be in place in order to have a meeting. The first is quorum. That's pretty obvious. I don't think we need to spend too much time on that. The second one is that it has to be a discussion that materially advances the business of council. So when all of you are sitting either virtually or in person at a council meeting, that's pretty easy to figure out. When it becomes a little more difficult and where councils find themselves in trouble is when I combine quorum and discussions that materially advance the business of council in other forums, such as an email discussion or a telephone discussion or informal meetings in the parking lot, in a restaurant, in someone's front room, etc. So anytime council has a quorum of members, a majority of council, you must be concerned that your discussions do not discuss matters that materially advance the decision-making of council. And I'll give you a few examples. So if you have an email that is sent to all of council and councillors begin a discussion about that item and they are using reply all, within that email thread, you have a quorum of council. And if that discussion is materially advancing the decision that council will make at a subsequent meeting, that email chain, that discussion, is in fact a meeting of council. The same would be true if you were just on a conference call or if you were all sitting down for lunch at a local restaurant. And so I'm not suggesting that council can't get together when we can all get together again and have a drink after a council meeting or have lunch together. But what you need to do is be mindful that you cannot discuss the business of council. And I appreciate that that is difficult because, let's face it, that's the one thing you all have in common is that you're all members of council. But you need to be sure that you're not taking yourselves down that path, because if you look at the final bullets, there are consequences to having what effectively would be an illegal closed meeting. There can be an investigation by a closed meeting investigator. If you haven't appointed a closed meeting investigator, the investigation is done by the ombudsman. The result of that investigation is a report that comes to council in a public session to tell you whether you did or did not have an illegal closed meeting. And there will be recommendations for council as to how to prevent that from happening again. The Act requires that you pass a resolution in an open session to indicate to the public how you're going to address those recommendations. So that's procedural. It doesn't really have a permanent, if I could call it that, impact. However, if you have a illegal closed meeting, which means there was no notice to the public and or it wasn't properly held in closed session because there was no resolution and perhaps because you didn't fit within the closed meeting requirements of Section 239, someone can take the municipality to court. And if a court declares that to be an illegal meeting, even if you went out in open session and discussed the same things and made a decision, that decision could be declared invalid. So notwithstanding that you may have, after this illegal closed meeting, had an open meeting where you made a decision, depending on the nature of the discussions in closed session, a court could declare that bylaw or resolution to be invalid. So that's a significant impact to the municipality. And so that's why I caution you to make sure you understand those rules. So I'm about to enter into the next section, which is conflict of interest. So, Your Worship, I wonder if there were any questions on the meeting section.
Anybody at all? Your hands in the air? Go ahead, Sheila.
Thank you. Through you to Tony. So basically you're saying if council was to have a discussion via email, copying everybody, and then discuss the same thing in open council, that's illegal.
And through you, Your Worship, it's essentially, yes, that's what I'm saying. Now, there are always, distinctions with that. So you might get away with doing just that, depending on the nature of the open session discussion and how fulsome it was in open session. I say that because I was involved in the city of Kingston in a matter that went all the way to the Court of Appeal, where council did essentially that. They had a closed meeting. It was declared illegal by the court, but in that meeting, they discussed a certain topic. But then they went back out into open session, and for 45 minutes, they debated that topic. And the court found that notwithstanding that the meeting was illegal, and any decisions made there in that closed session were also illegal, it was effectively cured by having a very fulsome discussion in open session. Now, I wouldn't suggest that you rely on that to try and have these illegal meetings thinking that you'll just have an open discussion and sort of quote unquote get away with it. It's not good practice. I can't recommend it. What I am recommending is that you not have those detailed email discussions. Avoid the reply all. And that should help you avoid. So it's not an issue if two counselors discuss something because it's not a quorum. It's that reply all function that drags us into trouble from time to time.
Thank you.
Anybody else? Okay.
All right.
We'll start. By the way, Tony, before we go on, I'm trying to get in the habit of getting everyone to utilize the hand up signal under your reactions. It makes it much easier. It's just something we have to get used to. So everyone keep that in mind. Tony, your hands up. Go ahead.
Next slide, please. So now we'll talk about conflict of interest. So this is something all counselors are familiar with to a certain extent. So it's always good to have a refresher just to make sure you understand it, because it does have some technical pieces that can trip us up. The first point that I always like to make is that this is a piece of legislation that is affecting you personally as a counselor. This isn't something that affects the township or staff. It is something you as an individual member of council have to decide for yourself, because it's your duty under this act to comply. And so it's not up to staff to tell you if you are or aren't, or potentially are or aren't in a conflict of interest. This is something you need to decide for yourself. And of course, as Integrity Commissioner, I'm always available if you have a question about that. You can ask me whether this is or isn't a conflict in advance of getting yourself into a place where you have to make a decision on the fly. It applies to members of committees and local boards as well. And it's important because obviously the penalties, as you see in the last three bullets, are fairly severe. A court could declare your seat to be vacant, and they can disqualify you from holding office for up to 7 years. So not just the balance of this term, but all of next term, and possibly a portion of the next term as well. So that's a pretty serious penalty. It doesn't happen very often, but it does happen. And if there was any sort of loss to any person, the court could also order restitution. Next slide, please. So what this is all about is money. It's a pecuniary interest. So could you, as a member of council or local board or committee, gain money or lose money because of the decision that council is being asked to make? That's your own personal direct pecuniary interest. But the Act goes a step further and deems certain indirect pecuniary interest to also be your personal pecuniary interest. And so if your parent, your spouse, your same-sex partner, or your child has a pecuniary interest in a matter before council, the Act deems that interest to be your personal interest as well. Now, what's obviously missing from that list is siblings. So your brother or your sister could have a financial interest in a contract that's coming before council. You can vote on, debate that particular matter, and it would not be a pecuniary interest under this Act. So you could not be charged or complained about under this Act. You could be under your code of conduct, but not this Act. The other thing to remember is that if your employer or your business partner has a pecuniary interest, the Act also deems that to be your pecuniary interest. And if you are a shareholder in a private corporation, that corporation's interest is yours. If you were fortunate enough to be a majority shareholder on a company traded on a stock exchange, you would also have the pecuniary interest of that company. Next slide, please. So there are certain things you must do if you have a pecuniary interest. Prior to council considering it, you must declare. As the mayor indicated today, there's always at the very, very beginning of every meeting a question, does anyone have a conflict to declare? That's the time to declare it. However, if you, for whatever reason, realize in the middle of the meeting or in the middle of a debate, oh my goodness, I think I have a pecuniary interest in this matter, don't wait. Once you figure that you do have it, that's the time to declare. Waiting it out is not going to help you. It's not great, obviously, to be in the middle of a debate and realize you might have a pecuniary interest, but it's much better to declare the moment that it becomes clear to you. And at that point, whether it's at the beginning of the meeting or the beginning of a matter or in the middle of a matter, at the point that you declare, you can no longer take part in the discussion and you cannot take part in the vote. The other part to remember is you are obligated not to in any way attempt to influence the vote. And that's before the meeting, during the meeting, or after the meeting. So obviously, if we look at the example of your spouse having a snow plowing contract that's coming up to council, you recognize that's on the agenda, you know you're going to declare, you cannot pick up the phone or send an email or talk to your councillors to convince them to give your wife their vote. That's pretty obvious. It's a little less obvious when the Act speaks to not attempting after the vote to influence the vote. It's a little less than intuitive in the sense that the vote's already happened. However, under your procedural bylaw, you can have council reconsider a matter. And so this Act also applies to any attempt to reconsider. So the councillor whose wife had the snowplow contract, if she lost that contract, the councillor can't then go to other councillors after the fact and attempt to convince them to bring forward a motion to reconsider. That would also breach the Act. You can stay in the room when it is an open session if you have a conflict. Not bad practice to leave the room, but it's up to you. The Act doesn't require it. However, if it is a closed session, you must leave the room. And the other final bullet point that's important is if you're away from a meeting, and if you had been there, you would have declared, the Act requires you to declare at the next meeting where you are present before council, just so that there is a record of what you did or did not have in terms of conflict of interest. We could take the next slide, please. And there are exceptions. So there are, I think, A through K in the Act, or maybe J, I can't remember. I'm just putting a few on the screen just to highlight ones that I deal with most often. The first one's having a pecuniary interest in common with other electors. The most obvious example is at budget time when you're deciding what property taxes are going to look like for the upcoming year. As a councillor, you will either reside in or own property in the municipality. Therefore, if you are voting to increase or decrease property taxes, that has a pecuniary impact on your property. And therefore, the province has given you an exemption because obviously we can't have a council of no members voting on property tax increases. That's pretty obvious. Fees and charges, also fairly similar. It gets a little trickier where we consider other types of groups that might have interests in common, because the way the act is drafted, it's not all electors in the municipality, it's any group with a defined interest. So the example I normally use is where we have a gravel road, and the vote before council is whether or not to pave that gravel road. So we all can appreciate that going from a gravel road to a paved road is going to increase property values on that road. If you own property on that road, then you have a pecuniary interest. Your property value will go up if you vote in favor of the paving. So that's the first part of the analysis, but that doesn't end the analysis, because now you know you have a pecuniary interest. The question is, can you take advantage of this exception? Do you have an interest in common with all of the other people who have houses on that road? The unfortunate part is there is no magic number. I can say with some confidence that if there's only 3 or 4 or less than 10 houses on the road, you probably can't take advantage of this exception because it's such a limited number of people. However, if it's a long road, there's 100 houses, you probably can, but it's very fact specific. So I would need to look at the facts in context to be able to give an opinion. The next opinion, receiving an allowance or an honorarium. Again, this allows council to vote up or vote down your own personal remuneration, an obvious exemption, because otherwise you could never talk about your own salary if it was a pecuniary interest. And then the last one is one that I spend probably most of my time on when councillors have questions about pecuniary interest. And that is whether the interest is so remote or insignificant, it couldn't reasonably be regarded as likely to influence the vote. What that means is, if you break it down, the cases have said it's what they call a reasonable person test. Would a reasonable person who's apprised of all the facts be more likely than not to say, I don't think that that particular interest, whatever that is likely to influence your vote because it's remote or it's insignificant, it's a small amount of money, or it's so unlikely to happen, that kind of thing. And this is obviously extremely fact specific, and we just have to look at all of the facts that surround it to figure out whether or not a reasonable person could come to that conclusion. So an example would be, and this comes from one of the cases where the councillor was a member of a university. The university came to council with an official plan amendment request. And the question for the court was, can that councillor vote on the official plan, even though the result of that vote is a pecuniary interest to the university, his or her employer? And the court found that it was remote because whether or not the OP amendment passed, it wouldn't affect the job, it wouldn't affect the salary, wouldn't affect prospects for promotion, etc. But you have to really peel back the onion and figure out what are the factors that we need to look at to be able to determine whether or not you can take advantage of that exception. So that's another good example where it's a reasonable place to ask the integrity commissioner for an opinion before you get down that road. We could have the next slide, please. So here we talk about the penalty. This is what happens if you get it wrong. So we've already talked about disqualification, losing your seat, and so on. The problem with this act previously was that those penalties, losing your seat, was the only penalty available to a court. And so judges were reluctant to remove members of council from office for what they perceived to be small or less significant matters. And the courts were relying on an exception in the act that talked about where it was a decision made in error, or it was made despite good faith attempts to, make the right decision. So we got all sorts of bad case law talking about finding errors or inadvertence, things like that, which is really just nothing more than the courts trying to avoid a finding that would remove a member from their seat. So the province recognized that the tool wasn't appropriate, and they broadened now the penalties that are available. So now a court could issue a reprimand, they could suspend your remuneration for up to 90 days, in addition to declaring your seat vacant. So they've just given the court more discretion. And with respect to my role as integrity commissioner, I don't have the authority to recommend any of those penalties to council under the Municipal Conflict of Interest Act. All I can do is refer the matter to the court and let the court decide. My role is to determine whether or not there are sufficient grounds and sufficient evidence to put the matter over to the court and let the court decide on the penalty. So, Your Worship, I'm about to move to the next topic. So I'm wondering if there are any questions on conflicts of interest.
Okay, I do see a hand in the air. Thank you for doing that, Heather. It's something we have to get used to. Go ahead, Heather.
Thank you, Your Worship. Through you, Mr. Fleming, going back to the point about just declaring a pecuniary interest in situations where the member is absent for the meeting in question. Does that apply also in cases where an item should arise or could arise, that is perhaps a notice of motion or other business or something that isn't otherwise on the agenda that would probably make our clerk cringe, but as the flow of meetings go, sometimes happen. Would that member be required to declare that even though they weren't aware that it was on the preceding agenda at the time the agenda was posted?
Through you, Your Worship. That would be a little difficult, obviously, because you may not even, you wouldn't know it's there on the agenda when you look at it in the first place because it wasn't added. I think that the answer is once you become aware of it, and that's probably when you see the minutes of that meeting and council's asked to approve it, I think that would be the time to declare and to indicate that you've just been made aware through the minutes that this matter was brought up and dealt with at the previous meeting or a couple meetings previous, and that's when you make your declaration. I don't think anyone would take issue with the fact that it may not have been the next meeting. If you didn't actually see the minutes, how would you know that it came up? So I think that's a reasonable approach to take.
Okay, thank you. I don't see any of the little hands in the corner. Oh, there's Tom with a real hand. Go ahead.
Thank you, Mr. Mayor. Through you, Tony, and you might have just kind of answered the question. I'm not real sure, but let's say I declare pecuniary interest in tonight's meeting, just hypothetical. And then next meeting and I leave the room, next meeting when we actually approve those minutes, should I abstain from doing that, or should we say all but that particular one because I had an interest and then do it separately, or how would we go about that?
Through you, Your Worship, I get this question quite a bit, and it's not quite intuitive in terms of the act just says you must declare, but the act is about declaring an interest where there's a decision of council. So in this case, when you're approving minutes, the quote unquote decision of council isn't to approve the matter where you had the actual conflict of interest. That decision was made by council. You properly declared and didn't participate in the debate or the vote. And now all you're being asked to do is approve that the minutes are reflecting accurately that council made that decision. I have no issue with you voting on those minutes because you're not approving the actual item itself or the decision. You're just approving that the minutes reflect that something else happened in the previous meeting.
Good question, good answer. Any other little hands in the air for Tony? Okay, go ahead, Tony.
All right, next slide, please. So now we're going to talk about council staff relations, and this is obviously a multi-layered topic. One of the things I always talk about with council is the hierarchy of council versus staff and the role council plays vis-a-vis the role staff plays. And this is set out in the Municipal Act, but I see this come up all the time in various councils across the province in terms of council members not respecting those roles or that hierarchy, and it creates certain problems that I'd like to highlight with you. So the obvious starting point is council sets policy and strategic direction. Your CAO or your manager, however you title that person in your municipality, directs staff to ensure that your goals and your direction is followed. And then managers and supervisors direct the frontline staff. That's the hierarchy that needs to be respected. And there is a legal component and a practical component as to why that's important. In terms of the legal component, the Act is very clear that all municipalities act by bylaw or resolution, and only a majority of council can approve a bylaw or resolution. That's council's role. That is you passing a bylaw, passing a policy, adopting a resolution to direct staff. That is your appropriate role in that hierarchy. An individual member of council has no legal authority to direct staff. Only the majority of council can do that, with the limited exception, of course, if council passed a bylaw or resolution to delegate its authority to an individual member of council. That would be the only exception. And so that's the legal reason why individual members of council cannot direct staff. The practical reason is set out in the very last two sub-bullets of this slide. So the first practical problem is that if you as an individual member of council take it upon yourself to direct staff, you put staff in a very difficult position, and it's counterproductive, because what you are doing is saying, managers, directors, you tell staff what to do. I, as a member of council, have to have the comfort level that that is going to get done. Where I take it upon myself as a member of council to step outside my role and tell individual staff members how to do their jobs, you need to appreciate how difficult that is for staff people, because staff answer to their immediate supervisor, who answers to their immediate manager, director, who answers to your CAO. The work plan for individual staff members is established based on budget, based on staff availability, based on council priorities. And so when you direct an individual as a member of council, what you're saying to that staff person is, I want you to do X. However, X may not be on that person's work plan. Not today, not tomorrow. Maybe it just isn't there at all. And so you put them in the place where they need to either do as the council member asks or do what their boss asked them to do. So if they do what you ask, and at the end of the day, their boss says, why didn't you do what you were supposed to do? They're in a very difficult position. And that should be enough. Let me put it that way. However, let me put another spin on it. Let's say we have another snowfall. That's going to happen. You get a call, which everybody does, talking about the fact their road hasn't been plowed, they need to get out, et cetera, et cetera. If you take it upon yourself as a member of council to call up Public Works and tell someone in Public Works to put a plow on this road because a resident is complaining, you have no authority legally to do that. But more importantly, if the staff person listens to you and takes the plow off a road that's scheduled, puts it on a road that isn't scheduled, you have created a situation where you're no longer following your snow removal plan and policy. If there is an accident on the road that you had the snowplow pulled from, the person who has that accident will sue, and the municipality, thanks to you, has no defense, because the road should have been plowed with the frequency and at the time that is dictated by your policy. By interfering with that, you've removed that defense from the municipality. That has serious impacts, obvious impacts on the person in the accident, but also financial impacts on the municipality, your insurance premiums, etc. So those are some practical and legal reasons why that ought not to happen. So if we can get the next slide, please. So these are a little out of order. I just realized that. So we can go to the next slide and then I'll jump back. So code of conduct. What this suggests is exactly what we were just talking about. Only council as a whole and no single member has the authority to direct employees, etc. And then we talk about respecting staff, acknowledging that they provide objective advice and stay neutral and so on. And then 8.3 talks about the requirement not to maliciously or falsely impugn. So I'm going to stop there and just say what I've just discussed with you is built into your code of conduct. So that is an obligation within the Municipal Act. It's also an obligation within the code of conduct. So if you step outside your proper role and start directing staff, that can be subject to a complaint under the code of conduct. So we go to the previous slide, please. So we'll jump back now and we'll leave the sort of hierarchy and we'll just talk about council and staff relations and how that's dealt with in your code. So section 3 provides that you have to treat members of the staff, members of council and the public with dignity, courtesy, and respect. It provides that you are at all times and always a representative of the township. So whether you are on social media, whether you're in the grocery store, whether you're in council chambers, whether you're walking through the hall of the municipal building, talking to staff, you cannot escape your obligations as a member of council, as set out in the code of conduct, to treat people with respect, dignity, and courtesy. So that is sort of the basic foundational respect obligation set out in the code. If we go to the next slide, please. And then the code in 8.2 and 8.3 gives more particulars about what your role is vis-a-vis staff and how you should be treating staff. So one of the things in 8.2 that I do see sometimes is the need to respect that staff are trying to provide neutral, objective advice. And it's not the situation that the recommendation in a staff report is intended to say to council, this is the only option that's available to you. It is the recommended option, certainly, but it doesn't mean you are constrained as a council member simply because staff have made a recommendation. It's your job as a councillor to respectfully question staff if there's a need to question staff, and to get the information you need as a member of council to make the decisions that are important to the municipality. But overall, you need to be mindful of the need to be respectful of staff when you're doing that. A good example, a few years ago, a mayor from Western Ontario disliked a staff report. It was a planning session. The mayor actually ripped the staff report in half in an open session. That became, surprise, surprise, the subject of a complaint to the Integrity Commission. That is the level of disrespect that I never want to see from any of my municipalities and the councillors. So I'm not expecting that's a problem in your municipality, we just want to remember that there is this obligation in the code that you always need to be cognizant of. If we can take the next slide, please. And so there's also in your municipality a council staff relations policy. This is a fairly new requirement of the Municipal Act. It's good to see that you have one. And I've just pulled 2 slides with some excerpts from that policy just to emphasize the point that we've just talked about. So, point 2 here, respect the chain of command, just reiterating what we talked about earlier with respect to the hierarchy, the fact that members of council have to respect the hierarchy, engage the CAO, not frontline staff. Number 3 is an interesting one that's talking about making good use of staff time. And I see this in some extreme situations where staff will complain that there is a member of council who's just constantly asking questions, constantly asking for information, and eating up staff time, to put it indelicately. So what your code talks about is making sure that requests go through the CAO or go through council to ensure that you're using those staff resources and that you're not personally going to individual staff members and sort of burdening that staff member unnecessarily. And it's an important point that I think sometimes gets missed, because counselors are always, in my view, acting from a good place. You just want the information you need because it's an important point and you want to make the right decision. I absolutely agree. I don't take any issue with that. I just ask you to be mindful of, again, the hierarchy and also staff time and resources. If you take that request through upper management or through council to upper management, then the managers can better direct their staff and manage their time and the limited resources that the municipality has. Next slide, please. So this is just another excerpt from the policy. 6 and 7 talk about members of council, treating staff well, not trying to play up divisions or conflicts, etc. And if you do have staff performance issues, that needs to go through the appropriate process. It ought not to be done in open session. It ought not to be done in a manner that is seen to be belittling or disrespectful of staff. You have a process in place, just follow that process. And then the last one, paragraph 7, again, stating what I hope is the obvious, and that is that your staff, your consultants are providing technical advice, and you should respect the fact that it is their area of expertise. And if you have questions, by all means, ask questions. Just make sure you're doing it respectfully and in a way that you're not dismissing their expertise or belittling their expertise. So, Your Worship, that is the end of the sort of council staff relations section. Before I move on to the procedural bylaw, are there any questions?
Okay, let me see the little hands in the corner of your screen. I don't believe I'm seeing anybody, but everyone is very attentive here, Tony. Good
All right.
stuff.
Good. Well,
keep going.
We're on track, so I think I can get you through the rest. So next slide, please. So we'll now move into the procedural bylaw. And as I said earlier, I'm just going to touch on essentially notice of motion and also points of order, because I do get a lot of questions about those 2 pieces. And I know that you've just done some amendments to your bylaw. So hopefully this can help you move through the new bylaw. So a notice of motion, this is in section 12 of your bylaw. If you bring a notice of motion at a meeting, that's not to be considered or debated until the next meeting. There is an exception. That's only for urgent motions, and it has to be provided by noon on the Tuesday prior to the meeting. And you need to go through 6.1, 6.2, which is just a process. In order to waive the process that you have in place in terms of the procedure and the timing for motions, you can rely on section 2.3, which is the provision that allows council to suspend the procedural bylaw. You need a 2/3 majority to do that. And it still needs to go through the process in terms of notice to the public. And there's a reason for that. And if you go to the next slide, we can talk about the reason for that. And so if you look at the code of conduct, especially 1.2, it says the public expects the highest moral, ethical standards of conduct from members. The behavior and actions of members is expected to reflect the principles of accountability, transparency, public trust. And then 1.3a, the decision-making process of council is open, accessible, and equitable, and respects the township's governance structure. So I put this slide in to demonstrate why it's important to follow the procedural bylaw requirements for notice of motion. Because if you get into a habit, or even if you don't have a habit, but it happens from time to time, that you simply bring a notice of motion at a meeting, council waives the procedural requirements, you debate and pass a resolution or bylaw related to that motion, no member of the public had any prior notice that that matter was being dealt with by council. So I'm not saying it is never to happen. There are certainly circumstances where it makes sense. You have it built into your bylaw for a reason, and that is that sometimes things just have to happen and things can't follow the necessarily normal process, but that should absolutely be the exception and not the rule. The reason being that the public are entitled to advance notice of matters that are coming to council, and for good reason. If it is a matter that deals with a specific property or a class of properties or a class of businesses, you ought to give those property owners or business owners the opportunity to bring a delegation to council so that you have their views. Maybe you've missed something. Maybe it's important to hear from those folks so that you understand both sides of the issue. And again, you have all the information you need to make the best decision for the community. If we can go to the next slide, please. You can call special meetings. There are rules for special meetings. The mayor can call a special meeting anytime by giving direction to the clerk. If a majority of members want a special meeting, they can bring a petition to the clerk. You need 48 hours notice to the public of that special meeting. And again, I reference here 2.3, which is 2/3 majority vote can suspend the procedural bylaw. However, you can't avoid the mandatory obligation in the Municipal Act for certain things, like public notice of meetings, having the meetings held in open, providing the public notice of when and how they can view or observe those meetings. So you can't get away from the openness and transparency, but for certain identified issues, it may be appropriate from time to time to suspend the procedural bylaw because it may just be necessary in order to conduct business. So the next slide, we talk about points of order. So this is a little different. Point of order is defined in your procedural bylaw, and that's a matter that any member considers a departure from or some kind of contravention of your rules or your procedures or generally accepted practices. So 11.1 says that if a member believes that their rights or privileges or the integrity of a member has been prejudicially affected, they can ask leave of the chair to raise a question of privilege. At the time a point of order is raised, it is always in order to deal with that, and it should be dealt with in advance of the motion that is on the floor. But what your bylaw does say is, and this is the last part of the paragraph, they shall not be permitted to enter into any argument or introduce a motion related to the question of privilege. So then if you look down below the point of order definition, 11.2 states, when a member desires to call attention to a violation of the rules of practice procedure, they ask leave of the chair, then they state the point of order succinctly, and the chair decides the point. So what you're saying in your procedural bylaw is that you're not going to engage in a debate about the nature of the point of order. The chair will just make a decision once the point of order has been explained obviously there has to be enough discussion in terms of explanation to know what it is that the point of order is all about. The chair then makes a ruling on the spot. However, members of council can challenge that ruling, and it would be done the way you would do a normal motion. Someone moves to challenge, someone seconds that, and then if you look at 11.4, then the question has to be put, shall the ruling of the chair be sustained? And again, that's voted on immediately and without debate. So it is a procedural allowance in your bylaw to allow a member to challenge how things are proceeding and whether or not it is in fact in order, but it is not intended to create significant, or any, in this case, debate, so that it's not derailing the business of council, but it does provide members with that opportunity to say, no, we are deviating from our rules of procedure. That's not appropriate. Chair makes a ruling. If the members disagree, you have a vote as to whether or not the majority disagree. That majority rule is final. Then you move on accordingly. And then the next slide. There are two other ways that you could raise this type of order or question, and that is a question of privilege or a point of information. A question of privilege deals with rights and privileges individually, and a point of information is just asking for more information. So all three of those, point of order, point of privilege, point of information, are dealt with procedurally in the same way that I just described. You raise the point of privilege or the point of information, brief description of why you're raising it, chair makes a ruling, it could be appealed, majority rules in terms of whether the chair's ruling is sustained or not. No debate. So that's the procedural bylaw piece. And then the last two slides, Your Worship, I talk about just complaint process, but before we get into that, keeping an eye on the time, perhaps now would be a good time to see if there are any questions about the procedural bylaw piece.
Okay, we do have a little hand. Carl, well done. Go ahead.
Thank you, Mr. Chair. I'm not sure, Tony, did you notice 12.1.2 of motions, putting a motion, notice a motion? We have a procedure in our procedural bylaw that something put forward is identified at one meeting, it gets carried to the next meeting, and then without debate, it goes to a third meeting, which extends what you want to do from about two meetings to six or, well, it could be 6 or 7 weeks.
Right. I did see that.
And I just wondered, what's your thoughts on that? I know at the county, we do it within 2 meetings, and I'm not sure the reason for why we have it at 3. But that doesn't mean we can change it too.
And through you, Your Worship, I obviously wasn't involved in the drafting, so I don't know the intent behind it, but I think you are reading it correctly. That's how I read it as well. I would agree with you that I see most often a 2-meeting cycle instead of a 3-meeting cycle. Okay. So all I would suggest is this is council's procedural bylaw. If that's not the process that you think is most efficient or that you want to follow, then you can certainly bring a motion to amend that procedural bylaw to deal with the timing of notice of motion.
Okay, thank you.
Anybody else? Carl can take his hand down. Good. We're getting on to it now.
All right, so if we can move to the next slide. So we'll go to the next slide. And so this is a complaint process. So this is just a bit of a summary or short form in terms of how complaints come through my office. I see mostly Municipal Conflict of Interest Act complaints or Code of Conduct complaints. I am empowered under the Act to deal with other ethical policies of the municipality. So an example of that might be your council staff relations policy. So that would be an example of another policy that I would have jurisdiction under the Municipal Act to have a complaint come through. Under the Municipal Conflict of Interest Act, any elector, myself, a municipality, or a person who's demonstrably acting in the public interest can apply to a judge. So this is drafted this way because under the conflict of interest legislation, as I indicated earlier, I don't make a recommendation to council for penalty. All I do, if I feel that there is a breach that is significant enough to go to a judge, I can make an application to the court. If, for example, I brought a report to council that says, I investigated a Municipal Conflict of Interest Act, I found there was a breach, but I don't believe it should go to a judge for the following reasons, you as a council could disagree and pass a resolution to bring an application before the courts. So that's available to you. Any individual in the municipality or anyone outside the municipality who demonstrates that they're acting in the public interest could also bring an application to a judge. It's a little different under the Code of Conduct because I'm not in that list anymore for obvious reasons, but any person, so whether they live in the municipality or not, any member of council as a whole, or staff can bring a complaint to my office that there's been a breach of the Code of Conduct. And I can tell you, I have had people suggest to me by way of a defense to a complaint that staff are not included in the act because the word staff doesn't appear in the act. It just says any person or any member of council or council can bring a complaint. In my view, it makes zero sense that staff would be excluded from any person. So I take complaints from staff routinely under this act. If we can go to the next slide, please. So this is the limitation period, and this is important this year because we're now in an election year. So under the MCIA, Municipal Conflict of Interest Act, any complaint must come in no more than 6 weeks after the alleged breach. That can be stretched a little bit if it didn't come to your attention right after. But I do require an affidavit saying when it did come to your attention so I can calculate the 6 weeks. There isn't a sort of a limitation period under the Act. We do have a 2-year limitation period in law and 1 year under the Ombudsman Act. Those are sort of guides for me, but there is no actual limitation period. What's relevant most relevant, I should say, for us this year is because it's an election year, after nomination day, which I believe is May 1st, no complaints can be filed with my office. After nomination day, if I had a complaint previously, I can't file any report with council. So if somebody brought a complaint today, I would have to wrap up that investigation, bring a report to council before the 1st of May. What happens on nomination day is all investigations that are in process but not resolved are terminated. After election day, the person who brought the complaint can write to me and have the complaint brought back to life, so to speak. But that has to be done within 6 weeks of election day. And this, for obvious reasons, the province is simply trying to ensure that during the election cycle, you're not weaponizing the complaint process and bringing complaints just as a political tool as opposed to a properly brought complaint with merit. And then the final slide talks about my process, and that is we do a preliminary review first. That's really me looking at the nuts and bolts of what's complained about, the code of conduct to make sure it actually could be a complaint. And then if there's any informal resolution, I always look for that if possible. If there isn't any resolution possible, we do an investigation, which results in a report with recommendations to council. And I think, Your Worship, I have hit 5 o'clock on the button.
I think you did. I didn't want to go any further. I might have to contact you about a complaint. So
yeah, I would not want that, sir.
you don't want to go there. Well, Tony, thank you very much. I don't see any more hands in the air, and we do have to scoot. Our council meeting should be starting now. I want to thank you very much, and I think this is something that we should review on a regular basis. I think you've done a great job, and we're kind of glad to have you on our side. So
All right,
thank you.
Your Worship. Enjoy your
Thank you
meeting.
very much.
Bye now.
Okay, that will conclude our meeting. I would like a motion, please, to adjourn. Sheila and Carl, you second it?
Yes, and I'll need a couple of minutes before our meeting.
Need a couple of minutes, okay. That motion is approved. All in favor? Okay, if everyone, it's a different link, remember, a separate link. If you could be back in 2.5 minutes, we'll start.